Hi, I would like to just welcome you and thank you for taking the time to watch this video. This is an adaptation of a talk that was given at the request of several people. We decided to put it into a video format. In the information age we live in today, with access to the internet that most of us have, there seems to be no shortage of access to data. The problem most of us have is that the data seems contradictory a lot of the times, and it's hard to form a base of understanding of what's going on. So the goal and purpose of this video is to provide you, the viewer, with an introduction to certain concepts that we may encounter in our lives, and give you a brief skeleton key or an outline of understanding that you, the viewer, can then build upon. And hopefully there'll be an opportunity to perhaps dispel some of the patriot mythologies that have arose and that are hindering people in certain ways. This is not an instructional video of any kind, nor will there be any legal advice given in any way. This presentation is purely fictional, based on uncommon sense that may or may not be accurate. And you, the viewer, as always, is encouraged to do your own research. Any information here comes from the public domain under fair use. All these things can be found on the internet. And be assured from the onset that other than suggesting people do their own research if they feel inspired to do so, this video in no way is suggesting that you, the viewer, does anything or take any action. Concepts. It has been said that there's nothing in this world that can be proven. Truth is what it is, and we just have our impressions or reactions to it based on our level of comprehension of what it is that we're experiencing. Most of us have heard of molecules, atoms, periodic tables, electrons, neutrons, protons. Some of us have heard of quarks, and perhaps you've even read up on string theory. However, most of us have never seen a quark or an electron or a molecule or even a cell. These are just constructs to help us understand what it is we're looking at. So, for example, if we see a wooden table, we can have a concept of how this comes to be in our world. The goal of this video is to examine and discuss some of the constructs we encounter in our world today that we may or may not be consciously aware of, so that we can recognize them with a clearer comprehension of what they are and what it means. One construct that most of us do understand is that an oven might be hot, or if it's raining out, we would then be able to take that information and know that we would act differently, as in bring an umbrella or a raincoat, or do not touch the stove. So having a clearer comprehension of certain concepts or constructs out there will help us in how we deal with them. Before we begin looking at these concepts, I would just like you to take a moment and take a look at the questionnaire. Please take a moment to answer the questions that you see on your screen. Now you can do this either writing them down or just take a moment to mentally answer them in your mind and just be clear on the answers. Ownership. So let's go back in time when there was gold and silver as currency, pre-1933. We want to take a look at the concept of owning something. So if B wanted to purchase a car from A, there would be an agreement for the amount of money, and then B would pay A for the vehicle, and then A would transfer the ownership to B. Now, a lot of people say that pre-1933 there was gold and silver and currency, backed currency, and that currency would then entitle B to actually own the car. Now, did you answer that you owned a car? So let's take a look at back pre-1933 if B provided payment by way of a negotiable instrument such as a check. Would that still constitute a valid sale? The negotiable instrument, such as a check, would probably involve a third party, such as a bank. And generally, where there's three parties to a transaction, it's a good indication that you're dealing with a trust. Trust. A trust has been described as someone giving something to another party over a period of time. Instead of A directly giving something to B, it is given to C to be held for B. Trusts, as I generally stated, have three positions. Now this can be two or more parties, but like I said, generally three positions. A would be the grantor, or the settlor, or the trustor. Now those words mean slightly different things in different jurisdictions and have slightly different functions, but generally there's somebody who has something to give away. And then the next party would be the trustee. That's the party that is holding the item. And the third one is the beneficiary. Now, only the true owner of something can put it into a trust. The grantor must be the owner of the item he's putting into the trust. So in the car illustration, with payment via instrument, the purchaser B could have given A gold immediately for the purchase of that vehicle, or he could have given him a negotiable instrument, in which case A would have had to take in that negotiable instrument to the bank to redeem the asset-backed currency. So that would have been a way of B giving something to A over a period of time. Now this appears in our lives, generally like house deals involving escrow agents would be an example of a trust. Trust funds for children's education, or even shipping. So somebody in today's world purchased something online and it was shipped out to them. As soon as the item gets shipped, who then becomes the owner of the item? Well, the trust creates an interesting concept of a bifurcation of title, a splitting of the title, if you will. So A is the absolute owner of whatever it is that he's going to put into the trust, the res, the item that goes into trust. The bifurcation happens when that title is now split between the legal title being held by the trustee and an equitable title held by the beneficiary. And therein title is split into two. Now, trusts were first used in England under common law when the knights went to go fight the Crusades. They would have ownership of their estates. They would have the absolute ownership of their property. And when they wanted to leave, they didn't want their property to be abandoned, but then it might still need maintenance and administration. So what they would do is they would find a party they trust and said, here, I would like you to have the ownership of my property, hold it for me until I return. And thereby they created a trust wherein they would give legal title to a friend while they were gone, and then when they come back, they would hope to retain that title. So they would retain the equitable title, and therein is the gift of property over time. Common law. In England, the time of the Knights and the Crusades, common law was the law of the land. So when the trust was created before the Knights left, the trustee is deemed to be the owner of the property. Common law sees the legal title as evidence of ownership. So while the Knights were gone, their friend, whoever they trusted with the property, with the title, would be the legal owner. And human nature being what it is, when the Knights came back, that sometimes created challenges. So if Robin of Locksley returned and the trustee didn't want to return his property, there was no remedy in the law. If the knight returning decided to sue the now owner, the trustee in the common law court, there was no remedy in the law to force the owner of the property to do anything with the property that he owned. The trustee was the owner, period. There was nothing the law could do to assist the knight. So the common law could not compel the owner to do anything, so the knight would have to then approach the matter in equity. Equity is found in the Exchequer courts. The Exchequer courts were also known as the courts of the king's conscience. And these courts were there to fulfill the law. Where there was no remedy in the law, there had to be a way to get things resolved, so they created the court of the king's conscience where they could bring in equity. So the knights could petition the king's conscience to take a look at what should have been done. An obvious example of what should have been done is the knight trusted his friend, and when he returned he wanted his property back. What should be done is the knight should be receiving his property back when he returns from the Crusades. So in equity, the beneficiary is deemed to be the owner, not because he actually is the owner, but because he has the capacity to compel the trustee to perform. And so we have a look at a maxims of equity here, and we can see that number 62 there, he who gets the benefit must bear the burden. And that's one of the very fundamental important things that you must remember about equity. And I want you to take the time to write this down and make sure you have that ingrained in your mind. That he who bears the benefit must also bear the burden. Ownership. So let's take a look at ownership. Ownership becomes a very funny thing when the knight's property while he was gone. Who really owns it? Well, the law, the common law, legal title represents ownership. At law, or in equity, equitable or beneficial title represents the ownership. So ownership becomes very, very relative to what law form we're looking at. So if ever anybody asks, do you own this property? The answer is always yes, and the answer is always no, depending on how they qualify the law form. So did you write down that you rode a car? Have you changed your mind yet? Well, let's just take a look at how car ownerships operate. When a vehicle gets created, generally the manufacturer issues an MSO or NEVIS, the manufacturer statement of origin. And so this basically describes the vehicle and is the absolute title for the vehicle. Once this vehicle gets registered with the state, the title is bifurcated. And out comes a certificate of ownership. So this would then be equitable ownership. And generally you can see the name of the owner on top, and the example on the screen, it says the province of Ontario. So in this case, the province of Ontario is the owner, and public, Jane Q is also the owner. So when this vehicle is purchased by someone, the current owner in equity would sell their rights to have possession of that vehicle to a new owner. The new owner would then go back to the trustee, to the province, to the vehicle licensing department, and compel the trustee to change the ownership to them. So a common law, the state would be the owner. In equity, the party driving the vehicle would be the owner. And so a similar situation arises with a mortgage deed of trust. Title is also split. So are you the trustee of the property in your mortgage deed? In the event of the foreclosure, is the lender looking for legal title, or are they seeking possession of the property? So then what did they sell you? Did they sell you legal title or equitable title? What is it that you're paying for? Money. So let's talk about money for a moment then. A lot of nonsense has been put out there that in today's world there is no money, and maybe that should be addressed and cleared up somewhat. Money is defined in the UCC General section of 1-201. Money means a medium of exchange currently authorized or adopted by a domestic or foreign government. Well, in that case, I would suggest that there is money in the world today. Could coins be money? Can wampum be money? Can gold be money? Can silver be money? Can asset-backed currency be money? Is today's currency asset-backed? Well, I would suggest that it is. Do we currently use gold at Starbucks to purchase a coffee? No, because that's not the medium of exchange that has been authorized or adopted by a domestic or foreign government. So coins are metal such as silver or gold, pure metal, pure gold, pure silver, could even be elements in the periodic table. These metals have been used to make items that what we refer to can be used as money, that have been authorized by the government. Currently, the government doesn't authorize the use of those anymore. So money is purely a medium of exchange, and I hope you get that. If tomorrow the government decided to adopt beads as money or IQD as money, guess what Starbucks will be accepting next week as money? Whatever the government authorizes there to be. So let's go back to when the party pre-1933 used a negotiable instrument as a check to purchase the vehicle. The check was not gold, but yet pre-1933 the party selling the vehicle would have been paid, would have been deemed paid. So I just want you to give that some thought and to understand that there is money in today's currency, in today's marketplace. So we take a look at money defined by the Canadian government. Money includes negotiable instruments. Negotiable instruments includes any check, draft, traveler's check, bill of exchange, postal note, money order, postal remittance, or other similar instrument. So these are again items that governments have authorized to be used as money. Banking. You can't use money without banks, so let's talk about banking for a moment. How many people have heard or believe that banks make money out of thin air? That has come up a lot with the people that I talk to. And it just makes me ask them a simple question generally. It's a great concept that the banks make money out of thin air. Then I would ask them, if the banks can print money out of thin air, then why are they stealing yours? It just seems like a lot of work that for somebody who can make money out of thin air that they need you to do it. Generally, when you go to a bank and you want to open an account, you would have to fill out an application. And if you do a bit of research on applications, basically to beg. You beg them to use an account. So if you're sitting in front of a banking officer and the banking officer gives you the forms to fill out to open an account, they would reach into a drawer and pull out a stack of, say, 10 checkbooks. They would take the rubber band off, lay one of the checkbooks on the table. And then they would put the rubber band around the remaining 9 and put them back in the drawer. So when you go down to open an account, they already have the checkbooks printed. They already have the banking cards already created. And so who's the owner of the account? The bank already owns the account, and the only thing you are doing is asking to use one of the accounts that they've already have established. Did you write down you own a bank account? Well, yes, the answer is you do own a bank account. Again, it depends on the assumption of law form. At common law, the bank owns the accounts. They're the trustee of them. In equity, you would own the account. So an account forms a trust relationship, whereas you would be a grantor, the bank would be the trustee, and you holding the debit card and the checkbook would be the beneficiary. And perhaps you should take a look at the back of the bank cards. Most of them will state, they used to all state, most of them in today's world state, this card is the property of the bank and must be returned upon request, just like on the Social Security cards. Today's world, a lot of them will just say this card is subject to the terms and conditions, and you have to do a little bit more work to go and find that verbiage. So when you have a bank account established, you can now deposit money into that account. So you're depositing negotiable instruments into the account. A deposit is a transfer of legal title. So if you've transferred legal title to the bank, that's another indication that the bank is nothing more than the trustee of that money. So the bank now owns those deposits at common law, and what do you own? Well, you own the equity. You can, in equity, compel the trustee to perform. Since we're after 1933 and we're living in the world of equity, you are deemed to be the owner of the account. So if you own the account, you can now order the bank to pay by check, pay to the order of, or you can order the bank to pay a merchant if you're using a debit or credit card. You can compel the bank to perform with the deposits that you have with that bank. So I want everybody to be really, really clear on this, and I would like you to write it down and always refer to it. Keep this in the forefront of your mind. An account creates a trust. Bank accounts, any account. An account creates a trust. A trust creates a beneficiary, or has a beneficiary. And in equity, which is after 1933, everyone is under equity. In equity, the beneficiary has the liability. So an account creates a trust has a beneficiary. In today's world, the beneficiary is deemed to be the owner. The owner of that account has the liability. So any deposits to an account will create a burden or a liability for the owner. So we're going to talk about that a little bit more, but just try to remember that. Liability, tax. So let's talk about liability and how that appears in our lives. Let's say that you are the party who has purchased a vehicle. You can compel the trustee to perform by transferring the title into your name. And now that you quote-unquote own the car in equity, who has to pay for the license plate sticker? Who has to pay the road tax every year? Who has to pay for the insurance? So let's say you work for a corporation and you're issued a paycheck. Is that paycheck money? Yes, in today's world that's money. Commonly those paychecks would get deposited into quote-unquote your account. So who owns the deposit? Well, the deposit is owned by the bank, but you have the liability of that deposit. A deposit is a transfer of legal title from one trustee to another trustee. So the trustee is now holding that deposit. You are the beneficiary of that deposit, and as beneficiary, you have the liability. So let's take a look at an account. Let's say you have his opening balance of 0, just for the sake of illustration, and your employer deposits $100,000 into that account. And again, for the sake of this illustration, we're going to assume a 50% tax liability. And so that deposit of $100,000 into your account will also trigger a corresponding $50,000 tax liability. So if you have $100,000 in your bank account and a $50,000 tax liability, how would you deal or settle that tax liability? Well, one way to do it is to issue an order to the trustee to pay that debt. Now that order can come in the form of a check or a credit card or a debit card. So let's say in this case we create a negotiable instrument, which is money, and you're going to use money to pay what we term money in today's world. You're going to use that money to pay the tax liability. So you pay to the order of the appropriate taxing agency and autograph your order so that the bank can perform their duties. Well, your previous balance was $100,000 in this case after the deposit. You have now paid the tax liability of $50,000, leaves a balance of $50,000 in your account. And that would settle the tax liability. So let's take a look at another type of bank. The bunk, the bench. So we the people, via democratic process, we passed a bill called the traffic law to reduce the debt. And that may be another story of how a checkbook reduces the debt, but the officer walks around with a checkbook to satisfy the bill that was approved by we the people. So is what the officer is doing his doing, or is he operating on behalf of the state? Well, the officer in uniform is acting as a legal personality of the state. Legal personality is another very important concept that I suggest you do a little bit more study on. So the officer issues a ticket. That ticket, of course, is a negotiable instrument. This instrument is generally deposited with the court. Now, you don't have to go to court. You can say, I will deal with this outside of court and honorably deal with your liability outside of court, or you can go to court and deal with it there. So this instrument is deposited with the clerk and gets put into a case with your name on it. So this is your account at the court. So the deposit has been made of one ticket. One instrument is now being held by the clerk with an account, court case number, with your name on it. So that creates the liability for you because it is your account. You're the owner of the account. So how would you deal with that liability? Well, just like we discussed before, if there's been a deposit of income into your bank account, you can now compel the trustee to perform. You can now compel the trustee, order the trustee, send a negotiable instrument from the trustee to the party demanding the liability. So, as a citizen, you're obligated to fulfill your duty. Fulfill means complete, and a duty is a tax. So by ordering the trustee to pay the tax, you would then have fulfilled your duties as a citizen. So speaking of police, let's go back to the example where you quote-unquote own a car and somebody has stolen your car. What would you do? You would generally call the police because someone has stolen your property. Now, are you the owner of the property? No. You are deemed to be the owner of the property. The rights you have is to possession and use of that car, and your rights to that vehicle is your property. When somebody has taken the car out of your driveway, then you have been removed or separated from your property, being your rights to use that car. So if we take a look at someone decides to ship a package to somebody, or you purchase something online and that item gets shipped to you. Now the truck that is transferring that shipment gets hijacked, and the package that has been shipped is stolen. Well, who would then call the police? Well, the shipper is not the beneficiary of the package, yet they would have the right to call the police to determine the location of their property and get that back. So the law that we look at today has to be very versatile. It has to deal in a situation of trust. It has to be able to deal with the rights of the trustee, and it has to be able to deal with the rights of the beneficiary. If you have purchased a package or purchased an item on email, and when the package has arrived, you've known it's been opened and the contents have been removed, well, then you would also have the right to call the police. So the law has to deal with both situations, both parties. Insurance. So a friend of mine recently purchased a computer and had it shipped out to another office for the accountant to use. When the package arrived, it was extremely badly damaged. It had probably been aggressively packaged, shall we say, or maybe even dropped extensively. In any event, when the package was opened, the computer inside was damaged beyond function. So, as most of us have experience with shipping, what would you guess happened? Well, there was an insurance claim. So the first $100 of the shipment was covered nominally by the shipper, but he was wise enough and decided to add extra insurance. So he paid an extra fee to insure the package for the full value of the computer. So in today's world, shipping is a little more tame, but accidents do happen. Years and years ago, when shipping was done over the oceans, it was a much more risky and dangerous undertaking. To take a look at the shipping, let's say that we have a contract whereas I agree to send 3 container loads of items, bananas, to someone in a port somewhere else. Well, I arrange with a captain of a vessel to take my containers on board and do the delivery. So there we have an example of a trust where I would give something that I own to another party, the beneficiary being at the port waiting for the containers, is getting something from me over a period of time. So we've established a trust. While the bananas are en route, the captain is bound by the law of peril. The law of peril is something else you should look up, that you'll see that it can be described as the captain can do and must do what he needs to do to protect the ship. So if the ship is coming under any kind of hazard or risk, the captain can and must do what he must to protect the ship. So in the case of a ship that is heavy loading, sinks further down into the water, and if there is rough water and waves coming on board and the ship is taking on water, the captain may need to jettison cargo. And so generally heavy items will be thrown overboard so that the ship comes out of the water more so that it can survive the waves, the storms. Now when that ship comes to port, there might have been 100 containers on that ship when it left, and when it arrives there's only 50 containers there. Well, that's when the law of contribution and general average takes place. Another concept that you might want to familiarize yourself with, the law of contribution or general average. So if someone had shipped 10 containers and then 50% of the cargo is jettisoned, generally what they would have to do is participate in subsidizing or compensating those that have lost cargo. And so in the case of my banana shipment, if something happened and my containers were jettisoned, or perhaps other people's containers were jettisoned, I might have to then donate or contribute some of my cargo to those that have lost theirs. Now that creates a problem because I still have a contract with the beneficiary where I agreed to deliver to them 3 container loads of bananas. And so because shipping was generally a hazardous undertaking, well, that's why they created insurance. So that if my cargo is jettisoned, I could then replace that cargo and I'd have to initiate a new shipment. Or if somebody else's cargo was jettisoned and I didn't want to give up my cargo because I needed to fulfill my contracts, well then I could in turn call on the insurance to go out and make good the shortfall of the jettisoned cargo. So Lloyd's of London is one of the earliest insurance companies for Admiralty Insurance. You can do some research on that. And one concept that you should know is the concept of subrogation. And subrogation has been talked about quite a bit. To make it very clear in your mind that if you have a vehicle, a car in your driveway, and it does have insurance, if you get into a situation where that car is written off and the insurance company must replace it, if they replace your damaged vehicle with a new one, you no longer own that old car. That old car is the property of the insurance company. So the containers that went over the ship is the property of the insurance company. And the insurance company can then go out and make restitutions. For example, if there was a negligent driver or somebody stole it, the insurance company can then go after what it needs to make whole on its claim. So one example of insurance is social insurance. Most people today have a social insurance number, a social security number. They have an account. And so again, the question is, are you the owner of the account? The answer is always yes. Now, we have to take out the assumption of law form. Are you the legal owner of the account, or are you the beneficial owner of the account? Did you go out and create the number, or did you fill out an application to somebody who already had the number and then ask them with a beg form, an application form, did you try to get use of one of their numbers? And so, are you the beneficial owner of that account? And if so, remember, where there is a trust, where there is an account, there is a trust. Where there's an account and a trust, there's a beneficiary. Where there's an account, a trust, and a beneficiary, there is liability to the quote-unquote owner, to the beneficial owner. Now, social insurance is actually mandated by the UN. If you do some research on the UN charters and UN laws, they actually state that Article 22 of the Declaration of Human Rights, everyone as a member of society has the right to Social Security. And so, even though it's mandated by the UN, social insurance is generally issued by the government. In Canada, Her Majesty via the HRDC, Human Resource Development Canada, generally issues social insurance numbers. In the US, it's Her Majesty via Social Security Administration that provides social security numbers. Again, these are no different than a bank account in the sense that you go in, fill in an application, a beg form, and then they go through their pool of numbers and assign you the next one in the list. And again, as we know, when an account established, someone is about to receive liability. So generally, we'll need to provide them with a birth certificate or citizenship card to go along with the application form. And now, every time that you wish to quote-unquote borrow money, you need to provide the social insurance or social security number. Generally, you will not get a loan or a credit card or any type of credit from a banking institution without that social insurance or social security number. So if there's any court action to collect a debt, you can see where now it would obviously involve an insurance policy. So in a court action to collect money, since it is involving an insurance policy, it is an admiralty jurisdiction because of the maritime insurance policy. Admiralty. If we take a look at the Federal Judicial Center, the website provides a lot of information about admiralty and maritime jurisdiction in federal courts. Federal courts are sitting in admiralty and enforce the nation's trade and revenue laws. The 1789 Judiciary Act, that's when these things were created, that the district courts have jurisdiction over all seizures under revenue. The majority of the admiralty cases brought before the district courts in the 1790s were government seizures to enforce revenue laws. Some parties challenged the legitimacy of non-jury admiralty trials to enforce revenue and trade laws, but the Supreme Court in 1796 have already upheld the constitutionality based on the fact that the proceedings were in rem rather than against individuals. So if you're going to challenge jurisdiction of the government, this has already been established in 1796 in admiralty courts. So the Constitution was very vague on that, but they left the federal courts to establish the boundaries of their own jurisdiction. The federal courts gave broad jurisdiction in admiralty over civil contracts, and the court ruled that the federal courts possessed admiralty jurisdiction over maritime insurance contracts, as we were just talking about. And so this gives a history of how it developed, the scope and jurisdiction thereof. The Supreme Court overturned the Thomas Jefferson and ruled that the Constitution granted the judiciary admiralty jurisdiction over all navigable waterways. All suits in rem were exclusive to the federal courts, since the common law had no similar procedure for dealing with such cases. In 1966, the Federal Rules of Civil Procedure were eliminated, the separate Admiralty docket and Admiralty rules. And so the courts of Admiralty and non-Admiralty were all merged into one. So we take a look at the Federal Statutes Annotated version 9 here, I guess. Talks about Article 3, Section 2. And we can see the judicial power to extend all cases in law and equity arising under the constitutional laws of the United States. And so it talks about the jurisdiction here. Distinction between law and equity. So it distinguishes the distinction between law and equity. So there is a difference between the two. And the party who claims legal title must proceed according to the form of practice. But if the claim is equity, one must proceed according to the rules. So if you're proceeding under common law, you must bring in the form. If you're proceeding in equity, you must proceed according to the rules. And so here's Section E, concurrent jurisdiction in common law. So district courts have jurisdiction over both. And then number 5, maritime contract torts and crimes. The admiralty jurisdiction in the case of contract depends on the primary nature of the contract. So we're going to scroll down a bit. Number 5, policy of insurance as a maritime contract. A policy of insurance is a maritime contract and therefore of the admiralty jurisdiction. Here's a snapshot of the IRS website under fair use. FICA. FICA stands for the Federal Insurance Contributions Act. Again, before I urged you to go and look up contributions. This is the Insurance Contribution Act. FICA taxes are composed of 2 separate taxes, Social Security and Medicare taxes. Take a look at Canada. For greater certainty, includes the internal waterways of Canada and the territorial sea. So Canada includes nothing more than the navigable waterways, which is subject to admiralty jurisdiction. Internal waterways in relation to Canada means is determined under the Oceans Act. So the definition of Canada is found in the Oceans Act. Now this includes the airspace above and the bed of the subsoil below those waters. So this isn't navigable waterways like what most people would have a construct of that to mean. To be clear, Canada is the navigable waterways that includes everything from the soil to the top of the airspace. And here's some more water, the Holy See. And so in terms of Canada's admiralty jurisdiction, Colonial Courts Act of 1890, and they wanted to clarify for everybody, Section 2, subparagraph 1, every court of law in a British possession which is for the time being declared in pursuance to this act to be a court of admiralty, or if no such declaration is in force in the possession, has therein original unlimited civil jurisdiction, shall be a court of admiralty. So they clarified that if anybody was not clear in 1890, these courts shall be a court of admiralty. So there will be some, hopefully there will be a data disk or on the DVD there will be some information put on that contains some information on Admiralty that you can do some reading on. There's also a lot of information on Admiralty on the internet. So when we're in a courtroom today, most of us can look up at the front and see a gold fringed flag in the courtroom you're standing in, which everybody, most people by now have figured out that that gold fringed flag is military flag. And the eagle on top means it is the flag of the commander-in-chief of the military. And so even when you go through Homeland Security checkpoints or airports, which is a port, of course, when you want to go through that port, you will need to go through an inspection station that also has a gold fringe flag with an eagle on top. Because these ports and the judges and the courthouses, these are all property, or they're all installations of the Federal Admiralty jurisdiction. So why do we need all this insurance and Admiralty jurisdiction, and why do we need all of these things? Well, the biggest reason is because everything is custodianship. This is why the UN mandates insurance. An example of custodianship, another good concept to go and study up on, would be a godparent taking possession of a minor, a child, a godchild, and the assets such as a check from the insurance or the parent's property in the event of a tragedy of the parents of the child. So somebody taking custody of a minor and the assets would be a custodianship relationship. There is an act called the UGMA, Uniform Gift to Minors Act, which states, in brief, assets, such as securities, where the donor has given up all possession and control, to be held in the custodian's name for the benefit of a minor, without an attorney needing to set up a special trust fund. And again, donor is another word for grantor, somebody who participates in setting up a trust. Assets such as securities where the donor has given up all possession and control to be held in the custodian's name for the benefit of the minor without an attorney needing to set up a special trust fund. And so another example of insurance for a custodian would be a bank account. Generally, bank accounts are insured by FDIC or CDIC. Stock markets. Well, if we take a look at the stock markets today, generally all securities are digital. Generally, these securities, stocks and bonds, are held in the global depository known as a DTC or the DTCC, held in a nominee owner by seed and company. If you have not heard of the DTC, Depository Trust Company, you might want to go and do some research on that. There is a lot of information. Just get a feeling for what this is and how that works. And so most of us buy our stocks and bonds if we participate in that via a broker. So the broker might go and establish an account where it can trade on the Securities Exchange Commission. And remember, where there is an account, there is a trust relationship. And so now you decide that you want to go and open an account to participate in the markets. So you open an account at an institution that participates in the market. Let's call it TD Ameritrade. So you fill out an application to get an account that they own. An account application creates a trust. A trust creates liability. So when you decide to go out in the markets now and quote-unquote purchase 5 IBM shares, well then who's the owner of the stocks? Because now we have a dual trust going on. So ownership again even becomes more interesting when you insert a custodian account in the middle, because now we have 2 trusts, 2 beneficiaries. Generally, the securities are held in the street name by the custodian, because you're the ultimate owner of those securities, but your custodian has to hold them somehow, and they will be held in a street name, which will be seen by the markets. Another way of establishing a custodianship is property transfer by will. So, for example, I write a will that says when I die, I want my property to go to my wife, who will live in that house for the rest of her lifetime, or until she no longer wants to live in that house, at which time the property will go to my son. So that creates a situation for my spouse where she has a life estate. And at the death, that property will transfer to my son, who is known as the remainder man. So at the point of my death, the property goes into my wife as a life estate. She will use it for her lifetime. and whatever's left over, whatever condition the house is in at her death, the remainder of that reverts back to my son. So the life estate has full use of the property, but obviously has a duty to protect. The life estate cannot damage the property willfully and put a toxic dump in the backyard or cut down all the trees or something that shouldn't be done, because they have a duty to protect the property, because it really isn't their property. They have use of somebody else's property. The remainder man is the naked owner. He holds the reversion. At the end of the life estate, when it is completed, the reversion goes to the remainder man. This is very similar to a usufruct. So this is an example we found on the internet under Louisiana law. A usufruct is a right by one person over the property of another. It is similar to a life estate at common law jurisdictions. Well, that's a very interesting term. If it is similar to a life estate in common law, generally the usufruct is not under common law. A usufruct can last for a specific period of time other than a lifetime. The person who owns the property is known as the naked owner, equivalent to the definition we had for remainder man in common law. So it's a very similar construct. An example would be that Michelle leaves a parcel of property to Hillary for life, with the remainder to pass at Biden at Hillary's death. In this type of arrangement, Hillary would have the right to the property that ultimately belongs to Biden. Hillary's right would be the usufruct, and her right would be called a usufructuary. Biden would be known as the naked owner. A usufruct is considered to be a real right under Louisiana law, meaning that it confers direct or immediate authority over real property. A usufruct can apply to real estate or other types of property. A usufructuary can use, possess, administer the property, as well as collect the income, utility, profits, and other advantages produced from the property. So for example, if the usufruct dealt with a farm, the usufructuary would be able to use the farm, sow crops, yield the crops, and have access to the harvest. So if we take a look at the usufructuary holds the property or an estate for a specific period of time, and at the end of that time the reversionary interest reverts back down to the remainder man. So here's some more definitions to help people understand this a little better. A usufruct is a legal institution in which someone who is not the owner is given the right to use and enjoy profits and advantage of something belonging to another, as long as the property is not damaged or altered in any way, for a certain period of time. At the end of that period of time, the property must be handed over to the person who really owns it. So usufructuary in civil law, one who has the right of enjoyment of a usufruct. So here we have the duties of a usufructuary. If you are the one holding somebody else's property, you must, 1, make an inventory of the things that are subject to the usufruct in the presence of those having an interest in them. 2, give a security for the restitution when the usufruct shall be at an end. 3, take good care of the things subject to the usufruct. 4, pay all the taxes and claims which arise while you are in possession. And 5, keep things in good repair at your own expense. So if you're holding if you are the usufructuary holding the estate for a period of time, somebody else's property, you must maintain it. You must pay the claims, the fees, the repairs, and you must preserve it. And you must have insurance on it so that when the usufruct comes at an end, the custodianship comes at an end, you must return the property and have insurance to make sure that you are able to do so. So we're going to take a look at how does this work in our lives that we look around us today. So what we've done is we've reviewed some of the concepts of trust and liability and ownership. And those are very, very important concepts. If you do not have a clear concept of who the owner is and whether you're the trustee or the beneficiary or if you're liable or not liable, it makes it very hard to understand what is actually happening in the world around us today. So the purpose of that exercise was to give you kind of an overview of some of the concepts that you might need to go and study, that you're very well versed in them, because we're going to take a look now at how these things appear in our lives today, and you're going to need to be cognizant or mindful of what this means. How does that relate? Are you the owner? Are you the liable party? You need to know those things to understand what it is that you're happening in the world today. What is it that's happening after 1933 in the world around us? So, and to take a look at how these concepts apply in our lives today, we're going to go right back to some of the beginnings of what we know, and that boils right back to the Bible. So let's go back to Genesis at the very beginning. And so we're going to take a look at Genesis 1:26. And God said, "Let us make man in our image, and after our likeness, and let them have dominion over all the fish of the sea, and the fowl of the air, and over all the cattle, and over all the earth, and over everything that creepeth and creepeth upon the earth." So God created something and gave it to man. So then in Genesis 3:24, so he drove out the man, and he placed them in the east of the garden at the Eden, the cherubims, and a flaming sword, which turned every way, to keep the way of the tree of life. And so something happened where we lost what God had given us, and we no longer have it. So then in Matthew 4:7-11, and Jesus said to him, "It is written, ye shall not tempt the Lord your God." Again the devil took him to an exceedingly high mountain, and showed him all the kingdoms of the world and their glory. And he said to him, "All these things I will give you, if you will fall down and worship me." And then Jesus said to him, "Away with you, Satan, for it is written, you shall worship the Lord your God, and him only shall you serve." And then the devil left him, and behold, the angels came and ministered to him. So, if God created the earth and gave it to man, and then we get to a situation where man has lost what God had given him, and then we have this man Jesus who's talking to somebody who says, "I will give you the cities." Well, Jesus didn't rebut that and say, "You don't own them." So then that begs the question, based on that, who owns the earth? Who owns these cities currently? So now we take a look at Galatians 4. "And now I say that the heir, as long as he is a child, does not differ at all from a slave, though he be master of all, but is under the guardians and steward until the time appointed by the Father. Even so, when we were children, we were in bondage under the elements of the world. But when the fullness of time had come, God sent forth his Son, born of a woman, born under the law, to redeem those who are under the law, that we might receive adoption as sons." And so that's a very, very interesting passage, because it denotes a lot of meaning if you understand the concepts. So, first of all, the heir. Well, somebody's an heir. If we take a look back to the will, where I left the property to my wife, and then when she passes it goes to my son is the heir of the property. My son is my heir anyway, but the heir is somebody who's waiting to inherit from somebody else. So the heir differs nothing from a slave, even though he is master of all, as long as he is a child. Okay? So the heir is treated like a slave, and he is under the guardians and steward until the time appointed. So there's that usufruct, can be for a life or for a period of time. And it talks about the children were in bondage to the elements of the world. And when the fullness of time had come, God sent forth his Son, born of a woman, born under the law, to redeem those who were under the law. So it seems that God had a plan to redeem those that were born under the law, that they might receive the adoption of sons. So the concept here is that it seems like the redemption is done, but the adoption as sons might be done. So I don't know necessarily that there's a limit on who was redeemed, but it certainly seems a limit on who might receive the adoption of sons. That doesn't seem to be automatic. So we're going to fast forward here to the King James Version of the same verse. And this looks a little bit different wording, but it's very interesting as well. Now I say the heir, as long as he is a child, differs nothing from a servant, though he be lord of all. And he is under the tutors and governors until the time appointed by the father. Okay, well, we take a look at the people waiting for the Messiah to come back in the day of the Bible. They were all under Roman governors, and they were held in bondage in the system of oppressive foreign military occupying their lands. And what they were waiting for was somebody to come, the Messiah to come and tackle Rome and get rid of the Roman governors, remove them under this bondage and an occupation that they were under. And so the Roman system at the time, they would go in and take over a land and put in governors to rule. So I ask, how many provinces in Canada have governors? How many states in the U.S. have governors? So the system that is established today has been run that way for a very, very long time. The grant of dominion has been made according to the will of God. We lost our inheritance under the common law, and there had to be a new covenant put in place that we might receive our inheritance. And so we see the rise of the Roman Empire. Joseph and Mary went to Bethlehem. Why? Because they needed to be registered. Rome decreed they must be registered where they were born. And again, the Jews wanted the Messiah to rise up against the Romans, to overthrow the Roman military. Now, under the Roman Emperor Constantine in 313 AD, Christianity was the official state religion. And our laws today are still called Roman civil law, except for Quebec and Louisiana. I mean, those are always the exceptions. But generally, we're under Roman civil law, and it is said that all roads lead to Rome. I'm sure most of us have heard that expression. Why would all roads lead to Rome? Well, the biggest reason is because they're all postal roads, part of the Holy Roman Empire. So if we take a look at what the Holy Roman Empire is, under Wikipedia, a multi-ethnic complex of territories in Europe during the medieval and early modern periods until its dissolution in 1806. And I'm going to suggest it wasn't actually dissolved. It is the largest territory of empire after 962 was the Kingdom of Germany. So it was a kingdom. So the king of the Romans. A prospective emperor first had to be elected king of the Romans. German kings had been elected since the 9th century, and at that point they were chosen by the leaders of the 5 most prominent tribes. In the Holy Roman Emperor, the main dukes and bishops of the kingdom elected the king of the Romans. After being elected, the king of the Romans could theoretically claim the title of emperor only after being crowned by the Pope. In many cases, this took several years while the king was held up by other tasks. So it's an interesting concept that the Roman Empire was all through Europe, even though we were told Rome was dissolved. So the Holy Roman Empire, I submit to you, was not dissolved, but it just simply moved. And so there was a king ruling things that had to be blessed by the Pope to become the emperor, to claim the title of emperor. Right of kings. These kings that were elective, that sooner or later became emperor, once they were voted in, they ruled under this concept of divine right of kings. So in Wikipedia, it is a political and religious doctrine of royal and political legitimacy. It asserts that the monarchy is subject to no earthly authority, deriving the right to rule directly from the will of God. So here we have again a will, we have a king, we have property, we have the authority to rule. All of this has been transferred. The Holy Roman Empire. So one of these emperors, known as Barbarossa, was the Holy Roman Emperor from 1155 until he died, of course. He was elected the King of Germany, and he was crowned the Roman Emperor by Pope Adrian IV in 1155. So Frederick was the first one to really start using this Justinian code. And so this is something that had been around for a while and then kind of lost a little bit of popularity, but it was brought back. So it is speculated that Pope Gregory the Seventh personally encouraged the Justinian rule of law. So the Pope is the one who had a copy of this law and brought it back to Barbarossa's attention. By the time Frederick assumed his throne, the legal system was still established on both sides of the Alps. He was the first to utilize the availability of the new professional class of lawyers. The civil law allowed Frederick to use these lawyers to administer his kingdom in a logical and consistent manner. A little further down, the claim of the divine right of kings had also been severely undermined. And so these kings were there ruling under the Roman occupation, and what they started doing, because people were maybe not so much happy with these kings and the concept that God wanted them to rule, and so what they did is they started using lawyers to administer their kingdom. So we're going to fast forward a little bit. It gives you a little bit of history of how Roman civil law came about and kings that rule. We're going to take a look past the Middle Ages here. We're going to go up to a time when there was a group called the Templars. Most of us have heard of the Knights Templar. We're going to take a look at what Wikipedia says. The Knights Templar were active from 1119 to 1312. Their allegiance was to the Pope. And of course, they were in the Temple of Mount Jerusalem, the Order of the Temple. And so, in Jerusalem, these Templars were under the tunnels of the Temple of Solomon. And Solomon, if you go back biblically, that's where the 666 comes from, if you take some time to research that in the Bible. And these Templars created and ran a tremendous international banking cartel. And this banking cartel spanned most of Europe, where you could go into one country and make a deposit and then go to another country and make a withdrawal. And this is in the 1200s, 1300s that this massive system was put into place. And it got to the point where they were, of course, banking and lending monarchies currency or money, and the monarchs couldn't pay the debt and the taxes to the Pope. So what eventually happened, from my reading, that they were discussing with the Pope that something needed to be done about these Templars, and the Pope ordered them destroyed. And so if you do a bit more reading on that, you'll see that's where we get Friday the 13th from, and that's why there's no 13th floor in most elevators, things like that. So after the destruction of the Templars on Friday the 13th, the Templars were no more, yet we still have international banking cartels. So the question then becomes, who took over the banking cartel? So we take a look at the Knights of Malta, or the Knights Hospitallers. So the wiki stats on that, well, they were started in 1099 and they're still active today. And again, their allegiance was to the papacy. So the Knights of Malta, or the Knights of Malta, the Knights of the Hospitaller, then perhaps might have taken over the banking cartel. They were connected with hospitals, the Franciscan monks, and we can take a look at some of their emblems, which is known as the Maltese Cross. So here's an example of the Maltese Cross, which of course looks very familiar, or similar to, I should say, the St. John's ambulance. And here you can see some examples of people using or wearing or displaying the Maltese Cross. Monarchies throughout the generations, both French and British, throughout the world, were using the Maltese Cross. So the system that's in place today, as I said, has been around for a very, very long time. Joseph and Mary went to Bethlehem to be registered under a decree from the Roman governor. So this system is administered by, well, it seems like the Pope is involved, it seems the monarchs are involved, it seems the lawyers are involved, the middle, inner, and outer temples are involved. And I would suggest to you that the civil system that we have in place today runs on a mirror of principles in biblical law, seeing that Christianity was made part of the state religion in Rome, which helped create the Justinian Code, Roman civil law. And so one concept I want to just impress upon people is the fact that whether you enjoy anchovies on your pizza or not, is that the Pope remains Catholic. Whether you like getting up early or not, the Pope remains Catholic, and the Queen is still the head of the Church of England. And so these people that take the position of Pope and that are Catholic, or these people that take the position of Queen, Her Majesty Queen Elizabeth II, head of the Church of England, they take those roles and hold those roles whether you care, don't care, love it, hate it, get up late, get up early. It doesn't matter to them what your position is. They hold these positions of authority. They hold these positions in a system that has been around for thousands of years. And so it has been said repeatedly that all the religions under the earth still follow Rome. Haven't really looked, but haven't really found anything that can prove that to you. But there is this solemn declaration of 1893 that I found, which talks about the Anglican Church of Canada. And in essence, it says, this statement establishes the Anglican Church of Canada's independence from the Church of England, while still preserving the bonds of communion. In the name of the Father, and the Son, and the Holy Ghost. Amen. So further in the declaration it says, we declare this church to be, and desire that it shall continue, in full communion with the Church of England throughout the world, as an integral portion of the one body of Christ, composed of the churches which unite under the one divine head and fellowship of the one holy Catholic and Apostolic Church. So it seems like they're declaring that even though they're separate from the Church of England, yes, they still want to be in communion with the Church of England, and they're part of the one holy Apostolic Church. Now, I'm not going to get into all the details. Like I said, I just found that. If that means something to you, great. If it means something different to you, that's okay too. And as we said before, that this whole system runs under Admiralty law. And so if we take a look at some of the people that are in charge of the globe, and here's the Royal Navy officer rank insignia, we can see some of the uniforms, the markings that they would have. And here's a gentleman that displays some of the markings, and if my eyes read that correctly, that would be the rank of Admiral. And here's another Admiral. And here's someone who is not quite Admiral yet, but seems to be in other pictures getting closer to the rank of Admiral. So this system that runs under Admiralty runs the globe.